The U.S. Supreme Court has just dropped a case on May 25th, 2023 called Sackett versus EPA. Why are we talking about the Environmental Protection Agency? Because we all know another agency, the ATF, that does so much as far as treading heavily when it comes to the Second Amendment. And the Supreme Court just dropped a decision that could seriously rein in the power in future court cases against the ATF. But also importantly, how does this fit in the overall picture? How does it fit in the overall context of where we are in the Second Amendment fight today? We're going to be going through all of that. Guys, let's get into it. So I really think that the context here is going to be really important. So we have a bunch of different actors that have been moving against the Second Amendment right now. This is probably not news to those of you who have been regular viewers of the channel, but a brief recap so you understand the importance of what we're talking about here. So we have different legislative bodies, whether at the state level, the local level, such as county boards, all that kind of stuff. And of course, at the federal level, who are constantly passing anti-Second Amendment laws, anti-self-defense laws, anti-victim laws, depending upon how you want to view it and interpret it, although all three of those are very, very fair. So we've got those on the one hand. Then we have administrative agencies, predominantly the ATF, who are allowed to basically interpret and enforce the laws passed by Congress. Why is that? So when Congress acts in Washington, D.C., it's impossible for them to forecast every single situation where these laws need to be interpreted and implied. And as such, the application of the laws and the specific ball strike calls sometimes need to be ferreted out by different agencies. Now, when we're talking about firearms, we're generally talking about the ATF, but there are approximately 438 federal agencies and sub-agencies across the United States regulating, well, a lot. I was going to use a swear word, but this is a family show, so I won't get there. So the bottom line to this is a lot of these agencies, now I'm going to focus back on the ATF, in many different persons' views, including my own, have done a lot to overstep in multiple different ways their delegated agency authority when it comes to interpreting and making reasonable interpretations, and they've done that broadly in two ways. The first thing that they do is they will basically overstep kind of what their own boundaries are. And largely, they're the ones, unless a court steps in, who get to kind of determine, yep, this is my playground, this is the boundary of my playground, and this is where I'm allowed to make these calls, and this is interpretation. In other words, they're often the ones that, unless a court steps in, gets to define the edges and the perimeter of their own authority. Kind of a scary situation. The second thing, of course, when we're talking about the ATF, particularly in May of 2023, as we sit here right now, just days before the pistol brace D-Day, is the fact that they are also flip-flopping constantly. We're going to be tying this all in. Stay with me. So what we're talking about here in Sackett, and I'm going to go through Sackett. I'm going to kind of pick out a couple different things that are going to be really useful here. But I'm going to, again, contextualize this for you and for the folks who have been watching a number of our videos. And you don't have to have watched all the other videos to follow this. But I want to show kind of the thread of jurisprudence that's emerging here, because this is kind of like plotting a trajectory on a map where, well, this court's making this decision, and this court's making this decision, and this court's making this decision, and they're all dots. And I want you guys to kind of see the line where if we connect these dots, where this is going, and I think it's actually going to be going to a good place here. But again, I want to make sure that you down the lens can follow this so you can see why I'm reaching these conclusions, not just the conclusions that I'm reaching. So we're talking about the Sacketts, who, and if you want to see the description, because I don't want to bore you with all the details really aren't relevant here, but I did throw in a quick factual summary of the case in the description box below. The gist to it is that they bought a home in Idaho, and they decided to basically move some dirt around in their yard in order to build a home. And the EPA said, hey, you can't do that because that dirt basically goes to this kind of wet soil, which goes into this ditch, which goes into this creek, which goes into this stream, which goes into this federal, this marsh. And we regulate the marsh, therefore we regulate everything that comes upstream of that. And the Sacketts are no, and they're threatened, I think, with fines of about $40,000 per day for noncompliance. off we go to the U.S. Supreme Court. And one of the key issues here is the interpretation of the 1972 Clean Water Act, which itself was a cleaned up and expanded version of the 1948 Federal Water Pollution Control Act. Now, the premise of the law was to regulate the pollutants that are expelled into waterways. And like many laws, that sounds pretty reasonable. I don't want dirty water. I'm sure you don't either. And of course, I particularly don't want water that's going to make my skin glow green and poisons my children. The big question that the case asks is whether or not the waters of the United States, which is the statutory wording that we're dealing with here, found in the law, what are those? What are the waters of the United States? And again, short version of the facts in the description box below. Now, this is an 82-page decision. And again, stay with me here. Stay with me. It's an 82-page decision with many different justices writing a maze of concurring opinions. So there's so much to unpack, and I'm trying to keep this short. So guys, if you want to see a longer version, let me know in the comments below, but I'm trying to keep this under 10 minutes or under 12 minutes, give or take. The court basically told the EPA, no, EPA. You do not get to take an exceedingly broad view of what constitutes the waters of the United States, which, by the way, if you go with the EPA's interpretation, loose story here, you actually arrive at a surface area that I think is greater than the combined size of, I think is it California and Texas, if memory serves. So we're not talking about an inconsequentially small amount of water here. We're talking about a huge area of water. And the court points out that a large part of the law's original intent was to keep the primary authority when it comes to regulating waterways vested in the state governmental power, not the federal government power. And that the EPA is, in fact, among other things, usurping this state authority by asking the courts to interpret the law in such a way that, well, they're asking for it to be interpreted that would give the authority to them. I want to point your attention to a short quote written in page 23 of the decision. Quote, "First, this court requires Congress to enact exceedingly clear language if it wishes to significantly alter the balance between federal and state power and the power of the government over private property." Fair enough. So the court's speaking to two things. One is the one I already talked on, which is the fact that states regulate waterways, federal government regulates waterways, and we have to basically regulate the interplay between state and federal power. So federalism, fair enough. But contained in there is something else I want to draw your attention to, where they said the power of government over private property. Could private property apply to things like, pistol braces? Could private property, of course, be, for that matter, bump stocks, FRT triggers, and all these other sorts of things, which is separate because we're dealing with what is a machine gun or what isn't, but just the same here. So you can kind of see the government sort of, and by that, I'm talking about the U.S. Supreme Court, threw out kind of a line to maybe grab onto. Second, and this is really the much bigger thing to my mind, though, and I've covered this many, many times on this channel, including in the discussion of the video linked in the description box below involving I think it was a Sixth Circuit Court of Appeals decision called Hardin versus ATF toward the end of April. Things get sticky when we're talking about criminal penalties. From page 24 of the decision, quote, "Due process requires Congress to define penal statutes with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement," end quote. What are we talking about here? We're going to be getting into a whole challenge for vagueness and the rule of lenity, which is a major theme going back to those connect the dots. This is a major theme in a lot of our discussions. The rule of vagueness, the rule of lenity is pretty simple. It basically goes something like this. When you have a criminal statute, the fastest way to get to tyranny is for the government to pass a very vague statute and then to interpret it in such a whole bunch of unforeseeable ways so good people who are trying to comply with the law can wind up going to jail for it. You want tyranny? That's how you get to tyranny. We don't want that. And I'm not suggesting that that's the manifest intent of the EPA or anything like that here. And I don't think that's what the court's suggesting either. But it stands to reason that there's a long-standing legal tradition in the United States in common law saying the rule of lenity, if a criminal defendant is charged with a crime that is basically so vague or is unreasonably vague or could be vague that when we go to interpret that statute, when we go to interpret the crime, the interpretation goes to the defendant in a criminal case. And what the U.S. Supreme Court here says throughout the Sackett decision is, look, a lot of these laws basically go towards criminal laws. And again, we see the same line of reasoning picked up on in Hardin as well as elsewhere when we're talking about bump stock cases, Cargill and so forth. That look, the ATF has adopted different positions when it comes to the legality of the possession of pistol braces, of FRT triggers, WOT triggers, all sorts of different things. Where initially they said things are perfectly legal until they changed their mind. So basically here you walk it into a rule of lenity situation where, hey, is this legal? Is this not legal? Is this vague? And what the Supreme Court did in Sackett is they basically have reined in a lot of the federal power, a lot of the deference. And I will note that Chevron is not noted once. You can do a Control F on the document that I linked below for the U.S. Supreme Court decision. Chevron will not appear in there. But make no mistake, it looms large because we're talking about the power of the fourth estate. We're talking about the power of agencies within government here. So before I kind of tie this all off, quick call to action for you. Guys, make sure that this video gets out there. I realize this is one of the more nerdy ones that we've done, but it is still very, very important. To do so, please consider clicking like. Of course, subscribe to make sure you do not miss any other future content. And of course, as you may or may not be aware, we also introduce memberships. If you are not a member, you lose nothing. The channel continues to be the exact same thing for you. Nothing gets taken away. We are adding some extras, though, for members. Check that out. We published a video on that a few days ago, so if you're interested, check that out. Just the same, we appreciate everybody being with us. So let's tie this all off. The really big thing I see coming up on this is we're going to see a case coming up dealing with Chevron that the U.S. Supreme Court actually granted a writ of certiorari, meaning that they are going to be hearing the case back on May 1st of 2023. That's the Loper case that's going to be coming up, which basically concerns with National Marine Fisheries Services and whether or not they've got different powers under the Chevron Doctrine, which gives agencies deference to interpret statutes. That's going to be a big one coming up when it comes to the ATF. This also deals with reining in the power of the federal government and that fourth estate of the agencies. But the biggest thing that I think Sackett stands for is once more underlying the vagueness and the lenity issues, the rule of lenity, L-E-N-I-T-Y, which goes exactly back to pistol braces, not to mention bump stocks and all these other things that the Fifth, that the Sixth Circuit, and hopefully others are all going to be seizing upon to basically tell the ATF, stop. You have to stop doing this. You cannot keep flip-flopping. You are going to damage, destroy, and ruin innocent people who are doing nothing but trying to comply with the laws and the rulings that you have made in the past. Guys, if you stuck with us this long, I sincerely appreciate it. And as always, we will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.